I'm Julie Bartkey with this Senate update. A proposal that would provide sweeping changes to the way juveniles are treated in the judicial system received a hearing in the Senate Judiciary Committee on Thursday. But before unveiling his bill in committee, Senator Latz led a news conference detailing his proposal.
This bill is about coming together to do what is right for the children in our society, some of whom run astray on occasion. But this bill will help them remain a part of the community and hopefully turn back to the path of being law-abiding and community contributing, which is the entire precept, the entire underpinning principle behind the juvenile justice system in Minnesota. The goal here is to keep kids out of the more severe parts of the juvenile justice system that don't need to be there, and allowing them the opportunity and giving them the tools with which they can, in fact, return to the right path in our community. And that, in turn, will help strengthen families who are trying to be supportive of their children in those circumstances as well. I want to note that this is truly a bipartisan effort. You have behind me some legislators from both political parties, because this is not about Democratic or Republican ideas, but it's about good, practical ideas to take care of our youth and our communities. I want to identify 6 critical components to this legislation. One is important to identify the purpose of the juvenile justice system, to reaffirm that it's about reducing juvenile delinquency and promoting public safety, and to recognize that kids, every child, has unique characteristics. Another component of this is to avoid shackling our children when they go to court. Now, most adults are not shackled when they go to court. Not unless the judge or the justice system in particular thinks that that individual defendant is really a strong threat to public safety, a risk for flight, or a threat to the safety of the persons in the courtroom. There's no need to treat juveniles any differently.
That's right.
In fact, on the contrary, it probably has a more dramatic and important impact on juveniles to shackle them when they go before a judge than it does on an adult. Another component to this bill would be to authorize police departments to conduct diversion of the juveniles who they come into contact with before those kids end up formally in the justice system, in the court system. We do this for some adults as well, and it's even more important, again, to do it for juveniles in appropriate circumstances. Because once you're on the public record in the court system, that public record can follow you for the rest of your life. If you have an opportunity to go through a pre-court diversion program, you can avoid that kind of stigma and have a chance to get back on track before it begins to haunt you more seriously down the road. We also are proposing to expand the Juvenile Detention Alternative Initiative, which has already established a track record in Minnesota of success, allowing alternatives that will allow juveniles to stay at home when appropriate and to lock up fewer kids, which will, of course, save money as well as be better for the long-term interests of the community. We're proposing to give judges more discretion in the sentences that they impose on juveniles, because every kid is different, just like everyone who comes into the justice system is different. But particularly for kids, the judges need to have the discretion to fashion an appropriate consequence, appropriate remedies for the situation that they're facing. And it's even harder to have a one-size-fits-all approach to sentencing when you're dealing with kids. We are also proposing to change the law to comply with a recent United States Supreme Court ruling with regard to life without parole for juveniles. And the court said that the district courts must take all of the circumstances surrounding that child into account when determining the sentence, and that mandatory life without parole is unconstitutional. So we need to give kids a chance, a meaningful chance, to get parole, even if it's many years down the road after they have served substantial time for some of the more heinous crimes. But the fact is, and this is just scientific fact, and we need to bring the law into alignment with this, that kids' brains are not fully developed.
That's right.
In fact, they're not really developed until they turn 25.
That's right.
So when they're 14, 15, 16, 17, even 18 years old, they don't have the kind of impulse control. They don't have the kind of ability to process what's not only right and wrong, but to recognize all the consequences of what they're doing. Now, there are some who commit the most serious of crimes that we'll never be able to do anything about. And we have to recognize that too. But there are some that will continue to develop, to grow, to learn, and that will be capable of living safe and productive lives outside of the prison system when they get older. We can't know which is which for sure when they're age 15 or 16 and they get sentenced to a life behind bars. So this bill would give them an opportunity after 20 years to petition the court to try to prove that they are capable at that time of living safely and productively outside of prison. The opportunity to convince the court that they're ready to be released. No guarantees, just the opportunity to petition for the court for that relief. And this bill also then would apply that same standard retroactively to the persons that are currently in prison under a mandatory life sentence who are juveniles at the time of the commission of their offense. And I'm not saying any one of those persons would get out, but they would in fact have an opportunity then to ask a court to review the circumstances of their case and the circumstances of their personal development to see if their release is appropriate. These reforms are important for all young people across Minnesota. But we also can't ignore the serious racial disparities that are in our juvenile justice system.
That's right. That's right.
Youth of color in Minnesota are arrested at almost 3 times the rate of white youth. And black youth are arrested at more than 5 times the rate of white youth. This has a significant negative impact on communities of color, affecting their employment, their housing, education, and more. So these bipartisan reforms to our juvenile justice system will help address these racial disparities and reduce the harm that's caused to those communities in particular.
For too long, our state has embraced really a one-size-fits-all approach to juvenile justice, where many kids that desperately need individual attention from our communities and families simply fall through the cracks. That system is unsustainable, and we've seen that. After 2 decades of a tough-on-crime approach, I think it's obvious that it's better to be smart on crime rather than tough on crime. Minnesota spends millions of dollars each year on juvenile programs that have proven time and time again that it simply does not work to decrease the crime rate. I'm proud to be the chief author of the Juvenile Justice Act in the House. As Senator Latz mentioned, this bipartisan bill is a real attempt to reform the juvenile justice system. We need to look at what we can do to help young people better their lives and not punish young people for mistakes early in life. A punishment that will follow them in many instances for the rest of their lives. Senator Latz has done a great job talking about a few key points of this legislation, and I'd like to just highlight a few that I think are especially important. You know, adults are arguably much more dangerous within a courtroom, and yet they're not mandated to be shackled. And so clearly the idea of mandated shackling for juvenile offenders is a severe problem that needs to be addressed. We need to have that determination be done on an individual basis, identifying the real flight risks and the real dangers of each offender. That needs to be addressed. We need to authorize our local departments to divert children who have minor, nonviolent encounters with the law out of the criminal justice system. We need to give them a chance. I want to emphasize again how successful the Juvenile Detention Alternatives Initiative has been. counties that using juvenile detention alternatives are locking up 66% fewer kids, saving taxpayers millions of dollars with absolutely no increase in crime. They're going about it a smart way. They're looking at diversion and helping children rather than detention and punishing children. We need that statewide.
Yeah.
And then finally, the U.S. Supreme Court has addressed the issue of juveniles sentenced to life in prison. And we need to fall in line. I think as a Minnesota legislature, when we look at Texas and Florida and Mississippi and see that they're already ahead of us on this,
Yeah. That's a problem.
there's an opportunity. There's an opportunity for us to make it right. And members, we need to do that. Alongside our growing bipartisan coalition of legislators, I'm proud to stand here in support of this bill that will ensure that all our youth have a meaningful second chance while saving taxpayers millions of dollars and stopping what we've seen for 2 decades as a fallacy. Being tough on crime, regardless of the situation, has not worked. It's time to be smart.
According to JDAI, Minnesota, each year, more than 2 million arrests are made of youth, resulting in approximately 300,000 to 600,000 admissions to secure detention. Of these children detained, 2/3 are racial or ethnic minorities. They are children of color. And we already know that African American children are disproportionately not only arrested but detained, and that translates into our prison system. Roughly a quarter of the children detained are acutely mentally ill. 80% of the girls detained report physical abuse, and 50% report sexual abuse. Broken children, our sons and daughters, our nieces and nephews, our grandchildren and great-grandchildren. We're warehousing our future. Whereas we could today begin to redeem them and restore them and help heal their brokenness and the brokenness of the families that they are part of. Think of the cost of not doing this. The cost of our faith and of our families. The cost to our communities and to the future of this state and this nation. These young people deserve to dream about a future with hope, a bright future, not one permanently darkened and marred by their past. So we call on the state to take action and to do it now, today. We can't wait. We won't wait.
That's right.
We think this should be a top priority for the legislature. And we stand with these legislatures today to say, pass this bill.
As a pastor and a counselor, I've invited people who have distanced themselves from each other to begin a conversation with these words: can we start over again? We have hundreds of youth, as you've heard, who are asking that same question. Can we start over again? The system denies them a redemptive answer. We have hundreds of youth who are treated as if they are dead, and we have the opportunity in this bill to give them life. If the laws don't reflect this movement, then what we are doing, we are holding people back from being all of what God has created them to be. It hurts individuals, and it hurts families, and it hurts whole communities when it is impossible to participate fully in life and work.
As far as I'm aware, law enforcement has concern, expressed to me anyway, only about 2 of the provisions. One, there's still some uncertainty, and I'm speaking globally in here now. A little bit of uncertainty about the shackling provision as to how it's worded and how it would work. And there's still not an agreement on what to do with regard to the juvenile life without parole provision. You may recall there was a bill last year to address that, and got caught up in the conference committee process and we were unsuccessful in brokering a consensus agreement on how to approach that. So that is still unresolved in terms of law enforcement's approach to it.